This is the In Focus podcast from The Hindu.
Hello, I'm Aaratrika Bhaumik and welcome to The Hindu. After a long wait of 16 months, the Union government on January 3rd unveiled the draft rules for implementing the Digital Personal Data Protection Act of 2023, India's first comprehensive data privacy legislation. The government is currently accepting stakeholder comments on the draft rules until February 18th, with plans to commence implementation mid-year. To delve into the intricacies of the draft rules as well as to address some of the concerns that they raise, we are joined today by Mr. Apar Gupta, an advocate practicing in Delhi who has been on the forefront of digital rights advocacy in India and is also the co-founder of the Internet Freedom Foundation. Thank you so much for joining us today, Mr. Gupta. To start off this conversation, what are your initial thoughts on the draft rules and how has the consultation process been as a stakeholder?
So I think what's important for us is first to separate the rules and what's contained within them from the process of the consultation itself. The consultation process extends till February 18th, and you can submit your comments on the MyGov online portal where the rules have been published in English and in Hindi in a 51-page odd gazette notification. So there's a high level of specificity, and for lawyers like me or experts or corporate houses or industry bodies, you know the language of the law in the form of a gazette notification. There's a 3-page accompanying explanatory memorandum which has a basic summarization of each provision in about 20 to 30 words, but that's only in English. Now, the reason I'm bringing up languages by itself is that a large number of people who will be impacted by this law, and this includes the ordinary person. It includes Lakshmi and it includes Lakshman. It not only includes people who are lawyers, experts, corporate houses. It's about the data of every human being. Right. So in a way, I don't think so. This consultation is framed in a way in which the ordinary person can actually submit comments, make their voice heard, or participate in the process. And even the policy choices, for instance, for experts like me, are not very evident because all you have is a prepared gazette notification with the phrasing of the law in its technicality and an explanatory memorandum which does not explain why that language is there.
Right.
So you don't know what was the intention of the draftsperson, why they made certain choices, what was disregarded, what was actually prioritized. And this then steps into the subsequent problem, which I'll discuss in a little time, of the vagueness problem, which is there both in the Act and the rules. Before I end, just like to point out one problem in the consultation process. The Union government had the pre-legislative consultation policy, which said that such kind of rule-making, administrative orders, or any kind of impact which people face on the basis of any kind of law which is made should be put to a democratic form of consultation, which means you need to invite public input because it increases the confidence in the law. It's not like the law is bad. Right. Per se, it's just that the people and the government in rule making need to be joint and stakeholders in a process in which trust is built, awareness is generated, etc., etc. Now, all the comments which is sent on these rules will be held in a fiduciary capacity, which essentially means that you can't requisition those comments either through the RTI Act, and the government also won't publish them. What that also means...
Or offer chance for counter comments.
Exactly, which the TRAI does. For instance, the Telecom Regulatory Authority of India publishes a consultation paper, may also have an annexure, what is the draft language they are proposing of a regulation, invites public comments, then you submit those comments. Those comments are published on its website under different stakeholder groups, individual, expert, industry body. Counter comments are then issued. Then it issues its recommendations and why it's making the changes. None of this is being followed here. So I think that there's a fair regression from the pre-legislative consultation policy. It's exclusionary and it will fail to build trust amongst the people who will be governed by this law, or at the very least, it will fail to build the awareness which is needed, because a large part of the any kind of law and regulation is its proactive enforcement with people knowing what it means.
Of course, of course. Before we proceed to the specific provisions of the rules, do you think the draft rules addresses some of the gaps that the Act left behind, or is there still a lot of scope for discretionary authority by the union government?
So I think there has been a conscious vagueness which has been adopted by the Digital Data Protection Act. Now, if you look at the process of how this law was made, of course, the law was being discussed in different committees, different government formations, even by a standing committee of parliament in different shapes and forms over a period of time. And they were building onto each other.
Right.
For instance, one discussion informed the next one. But the Digital Data Protection Act, which we have as a law, was suddenly introduced in a way in which the draft itself was pushed through parliament all of a sudden in a space of a week, I think so.
Right.
And after that, we have seen these rules after 16 months in a way, right? And when the act did come out in a way, and there was some comment invited on it, the first thing which we noticed was, why is it so intentionally vague? Because there was a phrase which is used as may be prescribed by the central government,
Right.
which means that the law itself was failing to specify to a certain specificity what are the principles under which now administrative rule making can be done subsequently. Because it was leaving those principles itself
Right.
to be determined not by parliament through the passage of the act, but through subsequent rule making.
Right.
So when you ask me this question, do the rules address the vagueness in the act? I would say that the rules are an obedient pupil in service of a disciplinarian, authoritarian teacher. It is following the same pattern. Here, the rules, when you look at it, have come under the same critique of being vague because a lot of the phrases are not defined.
Right.
They are not tied in with the General Clauses Act. The schedules which are prescribed can be changed as and when as per central government notification.
Right.
So in a way, the government has been consciously saying, we have kept the law vague because
What they're saying is they don't want to take a prospective approach.
Yes, we don't understand how data protection may play out. It may impact corporate interests. It may impact productivity. We are an economy which relies on a large amount of digital businesses doing well. We want our unicorns. So let's have the flexibility in the law which is needed, because the conventional understanding which is baked into the law is that the government will on a case-to-case basis determine. So the law as passed by parliament, the act as well as the rules remain vague. So we need to understand the government by these choices, while it may have that flexibility, it has also the flexibility of determining it on the case-to-case basis, person to person, entity to entity, and also purpose to purpose.
Right, right. So a key facet of the draft rules is that they require online platforms now to seek parental consent
Yes.
before they process a child's personal data.
Yes.
However, the rules do not really specify how this process is going to be undertaken, except asking entities to take appropriate technical and organizational measures. Now, my question to you here is twofold. First is, what happens, let's say, when a child puts in false information saying that he or she is above 18 years of age? Do the rules really address such a situation? And second is, if such parental consent is to be taken, let's say, through government-controlled digital locker services, does this not increase centralization also? Let's say, maybe it's a disproportionate measure. Do you believe it is a disproportionate measure that way?
So I think the underlying basis of requiring verifiable consent for minors actually needs to be first understood in terms of its implications before we come to what the rule imagines may be possible. And I say imagines may be possible is because I don't think so it can be implemented. Firstly, the phrase child has been defined at the age of 18. So at the age of 18, mostly as per the Indian Contract Act, you can't enter into a contract in a way because you don't have the capacity of understanding, and thereby it doesn't have a legal consequence. And your parents or your guardians are the ones who are the much more appropriate people to do that, right?
Right.
Now, there's a bit of a difference in digital services. In digital services, a person who's 14, 16, 17, or somebody who's 6 or 8 are very different in the way they access the internet. And if you require verifiable parental consent, let's imagine it's the best relationship between a child and their parent, in which the child has a high degree of autonomy and there is some modern soft parenting going on.
Right.
Even then, there will be some services which will not be uniquely positioned for India and will not have the ability, even when that child and that parent want to give that consent through a token based service, because that service, which may be a small educational provider, which may be exempt but may also be providing gaming services, etc., may be teaching a very specific skill like origami, for instance. It may just not have the ability of implementing an India specific compliance.
Right.
The second thing is it relies on, I think, universality of what is required in terms of identity verification for online platforms. What I mean by universality is that this is a Trojan horse, because the illustration which you used in your question was that what happens if a person simply goes on a website and says that, well, I'm over 18, even though I'm 16. How do you check that?
Exactly.
Then that means for every person above 18, you're also requiring them some form of verification. And the alternative which is given is that there can be a token based system in
Right.
which your identity is removed from that token and there's a credentialing authority. So the social media platform or the online service provider will not get to know your real world identity. So data won't increase in a way. However, this is not only for children. This will then apply to everyone.
Everyone.
And also, token based services do gather metadata in terms of when the authentication happens. I would say there are too many problems with this. And even if this regulation passes through the rules, we've seen a similar rule made under the IT rules where the government said that everyone who sends a message to everyone, there needs to be a traceability and an end-to-end encryption provider like WhatsApp or let's say Signal
Right.
needs to implement a system in which they need to fingerprint through appropriate technical measures. It's not been enforced ever, by the way. But the government wants to make these rules sometimes because it wants to negotiate with a large technology company sometimes.
Right.
That's my sense in terms of a reading of the political economy of why this is being done. I think it's unenforceable. If it is enforceable, it leads to mass surveillance, data maximization. And even when that does happen, it is essentially a lever for the government to say, these 3 services are exempt, these 2 services are there.
Right. And even if, let's say, parental consent is to be taken through virtual tokens, do we have any clarity as to how long this data will be withheld? Because under the rules, consent records have to be maintained for 7 years.
Yes.
So essentially, you have this data which has to be maintained for 7 years.
Yes. And I would say that mandatory retention, which is there, which is mandated retention, is there now in several laws. So India, as I've written before, has gone about a approach of data maximization, whereas in the doctrines of privacy and our understanding is that data, personal data by itself should not ordinarily be retained for long periods of time. It also makes me just think, on a principle basis, why is this being done? What is the concern? Are we concerned how social media is impacting the mental health of minors? If yes, what are the studies which have been commissioned by the union government? What studies have been commissioned by the NCPRI statutory bodies? What recommendations are there? Are we concerned with how much time young people are spending gaming? Is there an actual mental impact? Because I would also like to offer another less alarmist use case which is done in most instances. I think young people today are spending large amounts of time, in fact, actually attending classes when a smog hits our cities or when environmental conditions are not good or when there is a lockdown. I think young people get to build communities of trust and comfort online when they are introverted. I think it is an essential condition for people to move up in terms of social mobility, discover their skills, develop their personality, especially in their teen years. I do not think so. We should intervene and we should take away their autonomy by saying they're under 18 if there is no compelling scientific evidence on record. And I think while there is concern, I do acknowledge that there is some emerging science around it. I think the government needs to approach it more rationally rather than from a perspective of moral outrage or becoming another parent to every minor in this country.
Right. And if you look at the reality of Indian households, the digital literacy of the children, even if they're underage, is far greater than their parents. Like, I look at my young cousins, they know more about gadgets and how internet works than their parents. So we will also see situations where parents give blind consent. They are not aware of the
And only to
implications.
boys.
Yeah, of course. That is, of course, we
Yes,
have a,
because the boy has the smartphone in the
yes,
house.
of course.
Studies are showing this
You
again
have
and
the
again.
gender
and again.
disparity when it comes to
Exactly.
accessibility as well. Absolutely.
The government's own records are showing that women, I think the NSSO survey which did, whenever people have accessed the internet, which was their methodology was accessed it even once. It's almost like twice the number of women men are holding across most states. And I think it's deeply prevalent in patriarchal societies because women having Instagram accounts who are minors, a parent is susceptible to take away the smartphone from them much more quickly.
Yes.
Okay, so I think the government needs to think about this a little much more deeply.
Right. Another criticism of the draft rules is the data localization mandate that has been imposed on significant data fiduciaries as designated by the government. Do you think this could become like a major bugbear for large entities like Amazon, Meta, Google, and affect cross-border data transfers?
I think cross-border data transfers to some extent are already regulated. And if you look at experts like, for instance, Graham Greenleaf, he's a professor in Australia. For years, he's been doing a comparative analysis of data protection regulations. India is not the only country which is making this law, right? So what he has actually come to a policy understanding, and what I've come to understand by reading his work is that in certain specific ultra sensitive categories like financial data, you can ask for the residency of the data within the national borders of our country. There are also geopolitical concerns which are associated with it. But if you have vague standards in which the government can notify certain countries or certain entities as per its own discretion, then it's potentially left to a kind of a pick and choose approach, which in my view may become arbitrary. It may be a much more extraneous determination than a regulatory determination. Because let's remember, all of this is being done by my team, the Ministry of Electronics and Information Technology. It's not being done by a regulatory body like the RBI, which imposed data residency norms on, for instance, card networks to keep their data in India, right? And it did it across the board. So this is why I think when you can choose an entity, you have a vague amount of standards, you impose data localization, it may prevent the global interflows of data. And a lot of people may say, well, data sovereignty is very important. We need to keep our data within India. As a policy choice, the way to go about that is to build the underlying infrastructure capacity and to lower the unit cost of data residency within a country rather than approaching it through these form of regulations, because that ends up hindering the entire value chain. For instance, one global company which may be taking data on the basis of services it provides to people who are resident in Delhi, and that data may be going to data centers abroad for good reason, because there's a lower economic cost. They may be not able to offer those services in India, and because those services are not available in India, you cannot build on top of those services other businesses which are Indian businesses.
Right.
So I think the government needs to think about this a little much more deeply, because such kind of rules just increase the uncertainty in the regulatory domain and make foreign corporations wary of investing in India, which is also a government goal. So it conflicts with it very deeply.
And like you mentioned, there will be geopolitical considerations because, for let's say, the US law requires their entities and firms to have access to foreign nationals' data. So it will be difficult for such firms to operate in India if there is such data localization mandates.
And see, if there is a real geopolitical concern which emerges, I think there are models of laws and committees which determine first what is the company, what is the industrial sector in which they're investing, etc., or the activity they are conducting, and then they can place either any form of restrictions which are there, which are economic or in terms of technical controls. And I think this is what is needed. You can't package that within a data protection law by itself. The data protection law, let us remember, starts from the K.S. Puttaswamy's judgment in a way in which it is to ensure that information which is with respect to a person is shared in a way which is done with their consent. There is autonomy and control for ordinary Indians over that data. It's not a tool for geopolitical contouring of what technology companies get to work in India and which ones you want to impose what conditions on.
Right. Now, Section 36 of the Data Protection Act, along with now we have the Rule 22 of the rules,
Yes.
empowers the union government to call for the personal data of individuals and the languages in the interest of the sovereignty and integrity of India or the security of the state. Now, we have seen similar language in other statutes as well, and they are very broadly interpreted generally. So, do you believe that such a provision could be misused for state surveillance or to stifle dissent?
So the provision empowers the government as an additional power. So what are the powers which already exist? The powers which already exist under the new Telecom Act and the recently notified interception rules which they have made. Those rules and those powers allow it to issue orders to gather any kind of data, but they have to follow certain safeguards in which a written order needs to be issued, preferably by a higher ranking secretary such as the Home Secretary at the center or the state. It needs to contain reasons why that is being done. It is limited as per time, and then the records are kept in the complete confidentiality. Now these safeguards are deficient, but they exist, right? Now, second, what's the other power which is there? The other power which is there is to seize digital devices, and that's usually exercised by law enforcement whenever they are conducting a criminal investigation.
Right.
Again, what needs to be there before they seize a device? A criminal complaint, a preliminary inquiry, a first information report. What is Rule 22 and the section requiring? Nothing. It empowers the central government to requisition any data fiduciary, which means anybody who holds your or my data, to requisition that information, personal information, for any period of time. It says specified time, so it means any time, right? And then it also says that that order or that instruction which is issuing, the instruction it's issuing will not be revealed to you or me by that data fiduciary. It will be kept in secret. Now, it does not say if the instruction will be written or oral. It does not say whether the instruction will contain reasons or not.
So no safeguards whatsoever.
It will not say if those instructions will be repeatedly issued. It does not say if it is for a person, a class of persons, or all users on that platform. So, in a way, this gives a tremendous amount of power as per the authorized agencies that the central government may notify to intercept and collect information about us without our consent. And I think as much as there are phrases which are in the interests of the security of the state, etc., these are very broad phrases in a way.
Right.
And especially these broad phrases cannot be put to public scrutiny because we do not know that an instruction and order was issued against us. How is it issued? Under what conditions was it issued? So you can't even go to court and challenge it.
Right.
So in a lot of ways, I would say that this is a very dangerous power. It bypasses existing both surveillance powers under the Telecom Act as well as the processes to seize physical devices, because you don't need to seize a physical device because you have just made a phone call to let's say Google or Apple, where the entire backup of your personal information is there. This is extremely dangerous. It is unconstitutional because it conflicts with the Puttaswamy judgment and as well as the other safeguards which are there under several judgments which prescribe the and limit the power of the state.
Right. And you also see this compelling social media intermediaries like WhatsApp to end their end-to-end end-to-end encryption.
It can happen there, but I think the use case which is there most likely will be that if the government notifies a police department to have this power, it can potentially mean that they can ask a journalistic organization to turn over all employee records. If
Right.
that's kept in a computer,
Right.
they can because they are also a data fiduciary. What I'm trying to do through this example is also shift our imagination away from thinking that this law is about Google, Facebook, etc., Netflix, the big things which we see on our smartphone. It also applies to MSMEs. It also applies to non-profit service organizations, community organizations. It also applies to individuals in a way. Okay, so the government to a large extent has empowered itself to decide how this law will apply, pick winners and losers in the marketplace by determining how will it apply, and empowering itself and legalizing whatever it wants to do. So to me, I go back to your first question. Does this fix the gaps of vagueness which were there in the Principal Act? I would say no, it does not, because that vagueness is a flexibility which is desired by a government, which can lead to arbitrary action. And potentially, I think so, or probably will lead to arbitrary action.
Right. Now, another contentious aspect of Rule 22 and the draft rules in particular is the provision preventing data fiduciaries or intermediaries from disclosing such requests made by the government for personal data. Again, the language and the phrase used is in situations which could prejudicially affect the sovereignty and integrity of India or the security of the state. Now, do you think this is a disproportionate measure that again creates room for arbitrary government action?
Definitely. If you look at the Justice A.P. Shah committee report, which was done under the Planning Commission and surveyed privacy legislations across several countries and said that this should be privacy principles, etc., it stated that every time a person is placed under interception, they need to be informed they were placed under interception. That's because we have actually seen that interception orders have been used by police departments sometimes for extraneous purposes or under political pressure. Okay. Now, the second thing in this is that if a person does not know they have been surveilled, okay,
Right.
and after the surveillance has ended, they need to be informed about it. Right?
Right.
That's a reasonable middle ground, a reasonable safeguard which is there because that also keeps government honest.
Right.
It keeps it accountable. We know we were surveilled for this period of time for 6 months, and it may be disclosed. So if you're, let's say, surveilled for 6 months, right?
Right.
And then there is a cooling off period for another 6 months, and then the order is disclosed to you. You have the potential of checking and also inquiring why that action was done. It keeps government honest, keeps it limited. And I think it also reduces the burden which is there on a data fiduciary to challenge or to intermediate these things. To a large extent, we trust that when we turn over our personal data to data fiduciary, they will keep it for the purpose which is specified and they have asked us for that information.
Right.
It's not being done. Let me acknowledge it. But this law aims to fix that, right?
Right.
It says that whatever you share will be done with consent and will only be used for that purpose. Now, the government has created a giant backdoor and said that we can come whenever we want, you will not get to know, and we'll take your information and we will not even inform you after we have taken your information. We may retain it, we may do whatever we want. So I think there's a complete lack of any kind of checks and balances which is there under this rule.
Right. And like you mentioned that, when it comes to the obligations on these intermediaries, when you see the challenge of WhatsApp and Meta against the IT rules before the Delhi High Court, similar concerns were raised by them that, it'll be very difficult for us to operate if you compel us to break end-to-end encryption. So I think it just aggravates the concerns there. And also, another question is, and from my research, if we see the takedown regime right now, it is so opaque, and the primary complaint of stakeholders is that it is impossible to conjure up a defense. We don't know what the case against us is, because if you look at the blocking rules, again you have the confidential requirement here. Do you see similar concerns here as well when it comes to, let's say, having material to conjure up a defense?
So I would say that the government has not been constitutionally consistent. It's not followed the requirements under the constitution of any kind of legal order which has impact on a person's fundamental rights, requiring a high level of transparency, because that's one of the ways you can approach a court in a writ petition and challenge it, right? So it prevents the opportunity for a person to seek any kind of legal remedy in a way, and access to justice is one of the core pillars on the basis of which these accountability mechanisms work. So if you look at the Shreya Singhal judgment, in which section 66A was struck down, it upheld the power of the government to block websites, but stated, and this per the opinion of Justice Nariman, that the orders for blocking will ordinarily be open to writ jurisdiction of high courts.
Right.
Which meant that you need to have a copy of the order, then only you can file a writ petition, right?
Right.
Now the copy of the order itself is being claimed by the government in multiple litigations to be secret, confidential itself. So that by itself, according to me, is something which is constitutionally incongruent. But it's not only in the takedown regime or surveillance. We've even seen the same kind of arguments being used before the Supreme Court with respect to internet shutdowns, in which Anuradha Bhasin versus Union of India clarified that internet shutdown orders, which in fact impact lakhs, millions of people, right? That they need to be made public. So the government has been resisting transparency in the digital governance domain when it impacts any person's fundamental rights, and that has been a clear, consistent trend.
Right. Now, if we can discuss a little about the Data Protection Board of India under the draft rules,
Yes.
we have more clarity now on its institutional design.
Yes.
It's a very important functionary. It has almost all the powers of a civil court in this case. What is your opinion on the independence of this board now that there is more clarity on its functioning? Especially if you could talk a little about the Search Cum Selection Committee, which has been authorized to recommend appointments to this particular board, and it contains government officials. So, do you see autonomy when it comes to the functioning of this board?
So in 2006, the Planning Commission issued a paper at that point in time that what should be the approach with regard to regulatory bodies, and it noted expressly that concerns with respect to the functioning, appointment, selection, and service conditions of any kind of a regulatory body, especially its chairperson, should be never having any kind of impression of political bias attached to it. Now, why I'm bringing this up, it's important for us to first understand that the Data Protection Board is not a regulatory body. It cannot issue, for instance, standards, regulations. What it can do and what it only does is that it is an adjudication body, like a court. It decides whenever a complaint is made to it, if that complaint amounts to what in the act is called as a data breach, that whether you gave your consent and then it was misused, the notice was not given to you properly, or you gave consent for one thing and the data fiduciary used it for something else.
Right.
But the Data Protection Board, as per its design under the act, even as an adjudication body, is a subordinate of the union government. It does not have a physical office. It does not have any kind of physical infrastructure in place. It is a weak body. According to me, the Search Cum Selection Committee headed by the Cabinet Secretary can appoint any person, can make that recommendation. They are not the appointing authority. And also, in a way, one should look at it from the perspective that its recommendations are not binding on the union government. And the proceedings of the Search Cum Selection Committee will most probably not be transparent.
Right.
So, from the selection itself process, in which it may invite nominations, then make recommendations, who will be the candidates, how are they selected, we will not know. And then if you look at the service conditions, there is a clear reference to the central government employee standing rules with respect to leaves, entitlements, pay conditions, etc. So there is no security of tenure and service. And why I bring this up, the state is one of the biggest, and public authorities one of the biggest collectors of public information, personal information of people. Okay, now imagine, okay, I have to file a complaint for data breach, and data breach also includes data modification. For instance, one of the most common complaints we have is that our name is incorrectly noted in some government ID or the other. Under Data Protection Act, you have the right to modification and correction, which means that if I am Apar Gupta, you cannot call me Apurv Gupta in a government ID, and I finally have a right of redress and remedy to a data fiduciary asking them to change that. Now,
Right.
suppose I go to the transport department and the transport department is not doing it, then I can file a complaint with the data protection board as per a data breach. I'm imagining a scenario. A data protection board which has no independent authority, is there a possibility that it will feel that it has the power to decide against another government authority and impose a fine on it? And that's a big question for me. And I think that the data protection board, to a large extent, is under the thumb of the central government, because the central government can also make requests to it whenever it wants.
Right.
I would invite more people to look at the schedules of the chairperson, of the other members, as well as how the data protection board will be staffed. And I think so it will be very difficult for the ordinary Indian to seek remedy and redress for any kind of data breaches from it. And there's such a big question mark in my mind due to its institutional design about the risks of it having a level of political, at least the perception of political control.
Right. That actually brings us to the end of the discussion. Do you have any concluding thoughts or any other concerns regarding the rules that you would want to flag?
I would only encourage more people to engage with public materials, writing which is being done in several newspapers by several commentators, and ensure that they make their voices heard to the union government. This is an important law. It impacts all of us in a very, very day-to-day way, in a way. So I would just encourage more people to look at how they can participate with this law, put questions to each other, and just increase the amount of public awareness.
Thank you so much for your time, Mr. Gupta.
You're welcome.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.